The Supreme Court first reached this question in the early 1960s in two cases and held that teacher-led prescribed prayer in the public schools is unconstitutional. The first of these cases, Engel against Vitale, was in New York and involved what was called the Regent's Prayer. And the government literally composed this prayer. It named a committee with I think there was a Protestant clergyman and Catholic priest and a Jewish rabbi on the committee, and they got together and wrote this prayer. It was a government composed prayer that the students were all being asked to recite. Now, they weren't being compelled to recite it in the sense that they wouldn't be punished if they failed to do so. But in the coercive atmosphere of a public school, where when the teacher tells you, now we're going to recite a prayer or the Pledge of Allegiance, or we're going to read from the history book, or we're going to perform a play, or whatever it happens to be, we're going to go out and play soccer, you basically do what the teacher tells you to do. And the Supreme Court said that that's a kind of coercion around a government prescribed prayer. Now, I think that it was a very difficult case politically, but I think legally, that was another easy case. I think that's at the very core of what the Establishment Clause is designed to prevent, which is the use of government power to impose a religious practice on people that they have not freely chosen. And if it's being imposed by the government, that is the government stepping into a relationship that is supposed to be between each individual and their God. I think the hardest questions have to do with involvement of teachers, because teachers are individuals. They clearly have free exercise rights, but they are also authority figures. And it's often very difficult to draw the line between which of those hats are they wearing at a particular time. If a teacher wants to bow their head and say a prayer at the beginning of lunch in the cafeteria, they have the right to do that, even if students might observe that and it might actually influence students in some ways. Teachers have the right to wear religious symbols. They can wear crosses around their necks. A Jewish male teacher could wear a yarmulke. There was an important case in Oregon involving Sikhs wearing turbans, religiously identifiable garb. Can teachers read the Bible to themselves at their own desks? These have all been actual litigated cases. The most recent case, which is a very controversial and 5-4 decision, had to do with a teacher who was a football coach. At the end of the football game, he would go out and kneel on the 50-yard line and offer a prayer. These cases are hard, unlike, I think, the original school prayer cases, which in my opinion were politically hard but not legally hard. Cases like the coach on the 50-yard line are difficult precisely because teachers are both. They're both individuals with rights of their own, and they are also authority figures bearing the authority of the state through being teachers. And so it's really no wonder that cases like that have reasonable people on both sides.